Restoration application, my lord.
Have you served? No.
In course of the day, I'll serve, my lord.
Serve and come back.
My lord. My lord.
Do you have merit in your main application? No.
No, already it has been made, my lord. Already application. My lord.
Very well. Serve and come back.
My lord.
Mr. Amit appeared, Lord,
Hmm.
item 1, Lord, no further order is required because of the reason that the client is in touch with us, Lord, after we send the letter. Lord, I came and submitted before your lordship that I have sent the letter, and I'm awaiting for its delivery. So, Lord, he has contacted us, your lordship has fixed the matter on 10th. Lord, I'll be coming and bring the matter on 10th. My learned friend wanted to bring the matter under the to be mentioned because your lordship's desire was, even I submitted before your lordship, let there be an intimation through Mr. Rao. So already he has.
আমি কালকেই দুপুরবেলা মেনশন
So
করেছি
it's not required.
so
let it be
Matter will be taken up on 10th.
then my lord earlier order also is not required whereby your lordship directed me to made a communication through the local PS
Fine.
that
My lord will like.
so
I will not take note of the fact that Mr. Roy failed to discharge his duty. Don't worry.
Obliged. I'll come back on 10th, Lord.
then my lord kindly fix it on 10th
10th of May, it's fixed. Yes. Call the list. No order required. Hey, air করে দিন না 10th একটা yes ঠিক আছে লিখে দিন item number 1 no order is required to be passed no order is required to be passed
today up to 12 my lord up to 12
today up to 11:30
11:30 yes that is sufficient my lord judge সাহেবের বেঞ্চ আরেকটা বেঞ্চ আছে five I am from the state my lord or I am by it is Mr. Saurabh Chatterjee is appearing in this matter
দেখি কি আছে
My lord, item number 5, I'm praying for a short password. My lord.
সব কথা মনে আজকে আর হবে না 11:30 জজ সাহেব উঠে যাবে তাহলে কালকে করবে huge amount.
আরে তো এটা 500 করছি পরেরটা ডকুমেন্ট ডেকে দিন লিস্টটা ডেকে না
7, 8, 9, 9.
Yes.
Lordship, I am from petitioner number 1, 2, and 3.
Yes.
On the last occasion, Lordship, your Lordship had directed Mr. Basu, who was appearing for petitioner number 3.
Yes,
But now I'm appearing on behalf of him, and I had a talk with him. He was supposed to come here. He had intimated the opposite party, but they are not interested in coming.
where is the document?
Should I,
How OP number 2 was intimated?
through telephonic conversation. So he had told me that he'll be coming today.
I need to have certain thing to substantiate that anyway. Then what is the subject matter?
It's a quashing 482 case, Lordship. It's a criminal case, 482. Under section 420, 406, 120B.
Hmm. Why? Why? What's the reason it should be
Yes,
quashed?
if Lordship kindly sees the complaint petition, Lordship, it is annexed in the end.
Yes,
Chirag Trading, this is the complainant.
just hold on. Yes,
The complainant is Lordship Chirag Trading, represented by one named Mr. Ramesh Kumar Gupta.
hmm,
And I am a partnership firm, petitioner number 1, ARK Financial Services, which is a partnership firm, represented by petitioner number 2 and petitioner number 3, that is Rahul Saraf and Amit Mundra.
hmm,
Now, Lordship, should I read out the complaint petition, Lordship?
yes,
That the complainant company,
hmm,
page 90 over here, Lordship, that the complainant company deals in investment, having its offices at premises number 5 at Sagar Estate. The accused number 1 is a partnership firm, company deals in share business and also a member of National Stock Exchange Limited. That the accused number 2 and 3 are the partners of accused number 1. The accused number 4 is an agent of accused number 1. That the accused number 2 to 4 sometimes in the month of October. Lordship, this is very important, Lordship. In the month of October 2008,
hmm,
visited the office of the complainant
hmm,
and represented themselves as partners and agent of accused number 1
hmm,
and held out as follows.
hmm,
That the accused number 1 is a member of National Stock Exchange Limited, having its office at all over India and deals in share trading business run by accused number 2 to 4. That the accused number 1 shall purchase and sell shares for the complainant company under his instruction and consent. And against such transaction, whatever profit will come, that would be credited into the account of the complainant after the deduction of the service charges and brokerage as applicable. That the accused number 2 to 4, being the partners of the accused number 1, are solely responsible for the affair of the accused number 1 and also took after the day-to-day business of accused number 1. That the complainant, believing the version of the accused number 2 to 4 to be true, and upon good faith and being induced by the accused number 2 to 4, agreed to purchase shares through the accused persons, and hence the accused persons visited the residence of the complainant at premises number so and so, and the complainant paid a sum of 1 crore 20 lakhs in favor of accused number 1 in the following mode and manner. Then these are the check numbers, Lordship, through. So total amount, it is showing he has paid a total amount of 3.95 crores, 3 crores 95 lakhs. that the accused persons to build up their faith on the complainant company once remitted back rupees 2.75 crores, saying that the detailed accounting shall be shortly and the shares shall be delivered to it shortly, and also stated that a good sum of the wealth has been gained in the invested shares. That the complainant states that thereafter, whenever after repeated reminders and requests did not deliver the share to the complainant, and ultimately the complainant found that some of the accused persons have changed their mobile number and some of them stopped taking the call of the accused person. That the complainant states that lastly, in September 2012, the complainant reached the office of the reached the office of the accused and requested the accused person to either hand over the share certificates of rupees 1.2 crores or return the amount of rupees 1.2 crores if they have not purchased the share. Then the accused person threatened the complainant and his men and agent with dire consequences if the complainant and his staff, agent and man ever dare to ask either the share certificate or refund of 1.2 crores. That the complainant states that thereafter, while its letter dated 12th October 2012, lodged a written complaint with the Alipur police station against the accused person, but the police, instead of taking any steps, advised the complainant to take the shelter of the court. Hence, this case has been filed against under section 406, 420, 506 and 120B. So, Lordship, basically the complainant is claiming that we approached them, induced them, went to their office, and they believed in our version. And being a businessman, he gave us an amount of 3.95 crores to invest in share. Out of that, this was in October 2008. Out of that, to regain their trust, we repaid them an amount of 2.75 crores, and the remaining 1.2 crores, neither did we pay them nor did we give them the share certificate. Hence, after a lapse of 4 years, he has filed this complaint to get back his 1.1 crore 20 lakh rupees. Now, Lordship, this is a prima facie.
Why CBI is in the picture?
Yes, Lordship. Yes, Lordship. I'll come to it. Lordship, accused number 2, Rahul Saraf. He is a very close relative of the complainant, Ramesh Gupta. Rahul Saraf has a sister named Shweta Agarwal, and the complainant happens to be the brother-in-law of Shweta Agarwal. And Rahul Saraf was the sub-broker. The ARK Financial is a sub-broking firm. The main broker, the parent broker is the Motilal Oswal, which is a Mumbai-based firm. Now, in and around 2006, Chirag Trading, represented by Ramesh Gupta, he wanted to speculate in the share market. As ARK Financial is a sub-broking firm. The parent company is Motilal Oswal. My interest is that I am getting my brokerage. So this from 2006, this continued till 2 years. Now, after 2 years, in 2009, at around 4th April 2009, there was a CBI raid. In that CBI raid, I came to know that the complainant had been frauding the Central Bank of India and investing in the share market. So I denied that now I am not going to. The complainant was arrested. He was in the custody of the CBI for 3 months. Now I denied that now I'm not going to invest in the shares. After that, he started blackmailing me and he started filing false cases upon me one by one. Not only this, Lordship, he has filed more than 12 to 13 cases upon me and my family members. All my family members have been roped in. Now, Lordship.
Now, what about his money?
Yes.
He gave you 3 crores.
No, Lordship. Lordship, this is a prima facie false fabricated case without any supporting documents. Deliberately, he has not produced his bank statement. Where is his demat account if he wants the share certificates? No share certificate, no bank statement, nothing is there. It is just a mode of harassment. Blackmailing me because whatever he has lost in the share market, he wants me to again work for him. When I have denied, he has falsely roped all my family members in. And Lordship, this is the time in 2008 when we all know that in 1994-95, there was dematerialization of shares.
Payment was made through check.
Yes. Where is the supporting documents? Lordship, there he has not given any supporting document. He's
How
saying-
to hold that this proceeding is abuse of process of law? Whether he has any document or not, let the trial court decide. Why it should be quashed?
Lordship, even in the case diary, in the lower court record, there is no supporting document which he has given, nothing.
No, what is
The
the
basis
stage?
of-
What is the stage? Do you know what is the status of the case before the learned trial court?
It is fixed for framing of charges and the complainant is not even
No, you
appearing.
try your hand over there. You go and make out your case that there is no material to frame charge. Why it should be quashed? 482 cannot be invoked at the drop of hat.
Lordship, if
There
you,
has to have some serious materials.
Lordship, if I'm allowed, I can show the other papers where he has filed false cases upon my family members and I have been acquitted of all the false.
We are fine. That will not inure any benefit in this particular case. Every case has to be decided on its own merit.
Lordship,
If
even
you want to reap benefit, then you have to wait for the trial to come. Then you confront the witness. Then you make him admit, yes, frivolous, vexatious proceedings are being taken out against you. But in this proceeding under section 482, how it could be?
Lordship, there is one prima facie point, Lordship, in paragraph 4, Lordship.
Paragraph 4 of the petition.
Yes, Lordship.
Yes.
That the accused number 224 sometimes in the month of October 2008 visited the office of the complainant. Now here the complainant
Accused number
224 sometimes in the month of October,
paragraph 4.
paragraph number 4. Yes, Lordship.
What's the number of the complaint case?
Number of the Lordship
Complaint case, how it is registered? What's the number?
156.3. It has been registered and under section 156.3.
How many petition of complaints you have annexed? Page.
Page here it is, we have done it as 91, page 91, which is the last
Page 91. Certified copy of the petition of complaint.
yes, Lordship.
Yes.
Lordship, paragraph 4, Lordship.
Hmm.
That the accused number 224
Hmm.
sometimes in the month of October 2008
Hmm.
visited the office of the complainant and represented themselves as partners and agent.
Hmm.
Now, Lordship, this is October 2008.
Hmm.
Lordship, this is the master data and the annual report of the company, Lordship, where he's saying he was not even the director in October 2000. So under what locus standi did he file the case?
No. Did you receive checks from the
No, Lordship. No, Lordship. This is a completely false case.
that is the averment.
Yes, sir. Yes,
So
Lordship.
you wait, let it be decided by trial court.
Lordship, he has filed so many cases, Lordship, and it is very,
No.
and Lordship, he should have given his bank statement, even his bank statement is not here in the case
Charge sheet
diary.
has been filed.
Yes,
Then take down. Heard Miss Swanso on behalf of the learned counsel for the petitioner. This petition under consideration challenges the proceeding being See case number 7798 of 2012. Arising out of Alipur PS case number 375 of 2012, dated 30th November 2012, under section 406/420/120B of the Indian Penal Code, including the order dated 30th of November 2012, passed by learned Chief Judicial Magistrate, 24 Parganas South. Briefly stated, Hirab Trading Company Limited filed a petition of complaint before the learned Chief Judicial Magistrate, 24 Parganas South at Alipur, alleging inter alia that the accused, number one, being the partnership firm, deals in share business and also a member of National Stock Exchange Limited. Accused number 2 to 3 are the partners, and accused number 4 is the agent of accused number 1.
Lordship, and at the most,
Sometime-
Lordship, at the most, it is a civil dispute, Lordship. At the most, Lordship.
You have received check with a promise to invest the same in the share market, which you have not done. How it could be a civil dispute? Since inception, your intention is to.
Lordship, if I may, Lordship, show this document which is there in
These
the,
documents cannot be considered in this way. You have not annexed it to your petition.
Lordship, and there are so many cases, Lordship. I have the certified copies where he has filed false cases and I've got acquittal in all the cases.
So for that, you need to take him to the witness box and deal him with those documents. You have to confront him with the documents. In this proceeding 482, you cannot do this.
Sir, Lordship, and what is even more surprising is that I have gone through all the documents of the LCR. There is not a single evidence, but the charge sheet have been filed, Lordship.
You wait. Date of framing of charges before the learned trial court on
20th of July.
July.
Yes.
Go and bring everything to the notice of learned trial court. There is a provision.
Lordship, but it takes a very long time. It's a very
No,
long-
that is not the
No,
ground.
Lordship, but
No, you cannot circumvent the law in this manner. This is not a fit case for 482. Yes. Mm. Mm. The complainant paid a sum of rupees 1 crore 20 lakhs in favor of the accused number 1 to be invested in the share market. The accused persons no. No, I don't think
Lordship
it
is
is.
filing the case after 4 years.
12000, then 000. Hello? figure litigation 12000, then 000 in favor of accused number 1 by issuing 1, 2, 3, 4, 5, 6, 7 checks. Stop. In order to earn the confidence of the complainant company, the accused persons remitted back a sum of rupees 2.75 crores with the assurance that detailed accounting shall be done shortly. Detailed accounting shall be done shortly and shares shall be delivered to the complainant. But ultimately they refused to honor such undertaking. On sometime on or about September 2012, the complainant reached the office of the accused persons but he was threatened there with dire consequences. Thereafter, on 12th of October 2012, the complainant informed the Alipur police station about the incident, but no step was taken by police. The learned jurisdictional magistrate, after considering the petition of complaint, forwarded the same under section 156 within bracket 3 of the Code of Criminal Procedure and Alipur PS case number 375 dated 4th of December 2012 was registered. Learned counsel for the petitioner submits that the petition of complaint is vexatious, frivolous, and the accused persons are being harassed by the complainant, who has taken out several applications It is further submitted that the police, after investigation, submitted charge sheet, and it is further submitted at the board that after completion of investigation, police submitted charge sheet. And 12th July is fixed for consideration of charge before the learned.
20th July.
20th July, thank you. 20th July is fixed for consideration of charge by the accused persons. According to Ms. So-and-so, learned counsel for the petitioner, the complainant, though furnished a list of checks purportedly allegedly issued by him in favor of the accused company, but not a single document was annexed to substantiate such claim. Stop. Para. Upon careful perusal of the petition, I do not find any reason to invoke the provision of section 482 to quash the proceeding before the learned trial court. Stop. Revisional application does not merit any consideration. However, liberty is given to the petitioner to agitate all points before the learned trial court at the time of framing of charge, which will be duly considered by the learned trial court. Stop. With this, the divisional application is disposed of. Let a copy of the order sheet be sent down to learned trial court for information and necessary action. Yes.
Obligement.
Matter has been settled. Okay, Dinto.
2006 Milord, agreement was agreement was executed between the petitioner number 1 and opposite party number 2 regarding transfer of the vehicle. And Milord, all the installment about 11 lakhs was paid to the financer by the petitioner number 1. Thereafter, name of the petitioner was registered before the registering authority.
Who is Bobita Shao?
Babita Sahu. And
Is the de facto complainant?
yes, Milord. And after completion of investigation, Milord, FRP was filed, issue notice to the de facto complainant. De facto complaint was appeared before the court below, and Milord, case was dropped, discharged the petitioner.
Okay.
Ballot kindly.
What is the number, order number?
Order number, Milord, I am handing over the order dated 10/5/2013.
So why you are saying it is settled?
Yes, Milord.
How it is settled?
Last year,
There was no merit in the
Milord.
information.
Case is dropped, accused be discharged and. please
Okay.
allow me to-
Hey, Saurabh, this revisional application challenges the proceeding being GR number 3735 of 2010. Ekdom dhore dhore korben, kono bhul jeno noy, arising out of Jagodal PS case number 583 of 2010, dated 20th October 2010, under section 406, 468, 506, 120B of the IPC. Stop. Mr. Diwan, learned counsel for the petitioner, submits that police took up investigation and submitted FRT before the learned jurisdictional magistrate. Notice was issued upon the de facto complainant and with her consent, learned additional chief judicial magistrate Barakpur was pleased to accept the final report submitted by police in the form of FRT with a order dated when the order was passed.
CBS page Milord, 10 May 2013, 10/5.
With the order dated 10th of May 2013. Stop. Under such circumstances, this application for this application under consideration has become infructuous and is disposed of. Copy of the order passed by learned additional chief judicial magistrate 24 Forganas, not Barakpur, no?
Yes.
Is taken on record.
Grateful.
Well, the 12 and 13 of the same person, I'm appearing
Then
somewhat for a more moral reason, my lord. This man,
Moral reason.
moral reason, my lord. This
Okay, what
man
is that?
Case of way back in 2009 and one is 2007, out of Electricity Act.
Okay.
I've been enjoying stay, this man, but then I tried to communicate with this man. His son says that my father is not in a position to talk to even. His entire lower limb is unmovable. So in that case,
Fine.
my lord, I have nothing to argue with it. So your lordship passes any order. Only thing, if your lordship allows this person is to continue in the court below, Learned Court, he's on bail. That could at least show some sort of thing that he's not worse to appear and 205, this type of thing.
That you approach. Why you was
But
assuming that
he-
Learned Court is,
he is absolutely, this is the thing, he's absolutely sensitive. My father cannot go even to the toilet even.
it will be
On
considered by
instruction,
court.
said,
But this is compoundable.
I'll leave it to your lordship. This is
No,
the
why it can't be compounded? It's
I don't know whether
compoundable.
whether in between any compounding has taken place, so that's why left it open before your lordship, that whatever order your lordship passes, at least his representative will go to the court,
Okay.
if needed. I don't want for quashing, because without instruction, anything of that sort, it's a case of 2011, both the revision application, the police cases of 2007 and 2009. Electricity matters.
There was order of stay
Yes, well, there was. There was.
until further order. Yes, take down. Heard Mr. Mitchell, Learned Counsel, representing the petitioner. With all fairness, it is submitted at the bar that the petitioner is not in a position even to talk.
No, he can talk open, but he cannot move.
Oh, he can
When the
not
law
in a
limb is-
position to move because of palsy.
Because of some sort of sickness, in paralytic.
Yes, that is palsy. He cannot move.
No.
Stop.
On instruction, madam, on instruction.
Yes. As informed by his son. Stop. It is further submitted that the petition of complaint
Page. Page 11 is the FIR.
yes. It is submitted further that WBACDCL informed the jurisdictional police station that the petitioner made the company suffer loss of revenue to the tune of rupees 1,42,523
0.80.
0.80 as assessed provisionally, but the said contention is far from being correct. Stop. However, I do not consider it a fit case to invoke the provision of section 482 of the Code of Criminal Procedure. The petition stands dismissed. Considering the physical condition of the petitioner, Learned Trial Court is requested to consider
Yes.
to dispense with his personal appearance if
So application is made.
prayed for on behalf of the accused person. Stop. Liberty, however, is given to the petitioner to take up, to agitate all points before the Learned Trial Court. Let copy of the order should be
But
sent down to
similar
the
on next case as well. But Mr.
I am
President,
appearing. Oh, heard Mr. Bhattacharya representing the state. You are not the lawyer of WBSCDCL. No, this is state has got nothing to do.
But the FIR is lost.
FIR lodged, so what?
Yes, just after.
Suppose Ram approached police and FIR is lodged. He will shoulder the responsibility of Ram. I পরেরটা অ্যামাউন্টটা দেখে ঠিক করে দেবেন।
কেস নাম্বারটাও চেঞ্জ করে।
হ্যাঁ সৌরভ ওটা একটু দেখে কন্টেন্টটা ফিগারটা আর নাম্বারটা এটা কি ওই দি সেম ওয়ান এখানে অ্যামাউন্টটা বলে দিন
Amount is, I'm giving you my lord. Put the amount to put that. I think no amount is stated there. Page 11 is the FIR. That was the-
It was your magnanimity. You didn't make the company suffer any loss.
I paid back, I believe.
You paid back.
I don't, this was
I don't know, there is no reflection.
in the FIR.
Empowered by provision.
The amount has been mentioned that maybe there, those days when the pressure was so much on certain customers on the village side, Midnapur and other places. One after another cases they used to suffer. And then there's a coercive measure to collect the revenue. However,
Without the amount, you just say, I don't find any reason to invoke the provision.
but may take a
Come on,
liberty, but item 80.
80,
80, but just not, this come today, I'll take 1 day adjournment, 1 week adjournment.
okay.
80,
Let it
Pali
be.
market.
Nakun,
I'm grateful. 80 to market, I'm grateful, deeply.
Thank you. Nakun. Call the. It will not take more than half a minute. No.
My lord, the petitioner before your lordship has sought for washing of a proceeding
Then what is
on the ground that, my lord, the petitioner should have been discharged in accordance with section 167, subsection 5, West Bengal Amendment. My lord,
No.
here in
What
this
is,
case,
what is your number? CRR 1809 of 2012.
537.
15.
15.
My God. Hey, Adito, 15 doesn't.
537. Yeah.
There was implied extension of time.
No. There
No.
was the implied, my lord, will see from the order sheets I will show to your lordship, there is a substantial miscarriage of justice which has taken place in this case. Because it was done very mechanically. My lord, the petitioner was admittedly arrested and produced on 4th July 2009. There's a case
Okay.
under section 409 amongst other
Yes.
407. So my lord, the 2 years, according to the 167 subsection 5, the period would be 2 years. So he was produced on 4th July 2007. The 2 years completed on 4th July 2009.
Yes.
Now, my lord, comes to the order sheets. First, my lord, I have annexed these certified copies from the order sheets. Lordship would be able to. I am giving a brief summary of petition. I am giving a brief summary. My lord, the date then relevant is 4th July 2009. So from 4th July 2009 or prior to 4th July 2009, there is no application for extension of time to complete investigation. My lord, on 13th September 2010, that is after more than 1 year from 4th July 2009, the investigating officer makes the first prayer for extension. The prayer itself is extremely mechanical and there is no reflection.
13th of
13th
July,
September 2010.
13th September 2010.
My lord has got the order of 13th September. My lord,
No, 13th September 2010. Send the prayer of IO who prays for time to complete investigation as missing non-judicial stamps are not yet to be recovered, etc., etc.
vital document
Fine.
yet to be seized. If I am not wrong, this is still the situation. It has not been recovered. Anyhow, my lord, on 13th September 2010, this prayer is made. The prayer is allowed. My lord, I am fundamentally on this. I am coming back to this point again. Whether he could have made this prayer on 13th September 2010. Now, my lord, on 13th September 2010, the date is fixed on 27th December 2010 for the investigating officer's report. Now, my lord, we'll see on 27th December 2010, the second prayer for there was no report from IO. 19th May 2011 for IO's report. Already mechanically the ACGM had already extended the time till 19th May. Then afterwards, the investigating officer files a petition once again who prays for further time to continue with the investigation as the investigation of the case could not be completed, considered allowed. Again, 19th May fixed. Now, my lord, on 19th May 2011, third prayer of extension of time. Okay. See in the prayer of the IO who prays for further time to complete investigation, prayer of IO is allowed. Let it be kept with the record. IO is directed to here for the first time, the learned magistrate takes some steps and asks him to be present personally before this court for consideration of his prayer. And on 23rd June 2011, the prayer is once again allowed. IO is present today. Prayer of IO is allowed for 2 months as last chance. Now, my lord, there is a prayer which is allowed for 2 months. Then 23rd August 2011 is the date of the last chance given to the investigating officer. On 23rd August, my lord, again
Why did you not move your petition before the learned trial court?
my lord, we moved. I will show to your lordship. My lord, we'll first see 23rd August 2011's application on that date was, my lord, virtually dismissed for default. It was a default on the part of the, my lord, kindly, my lord, humbly I submit before your lordship. It is a question of substantial prejudice and substantial question of law. My lord, here there was a non-appearance on the part of the learned counsel for which the application was rejected. My lord, this rejection is not a rejection on merit, as lordship can appreciate from the record. It is a dismissal on merit. Now, my lord, we'll see why I make this becomes relevant is that my prayer is kept this after being dismissed for default. This prayer was being dismissed for default on 23rd August. My lord, on 23rd August 2011, it is the last chance. My lord, even otherwise it is a last chance. It is almost like, my lord, will draw a parallel between a right accrued by a person in the case of statutory bail and a right accrued by a person under section 167 subsection 5. My lord, now the law has almost boiled down to this, that even if that person does not move the application for statutory bail, the court loses the power to remand the person for after the completion of 180 days in case of special acts, Narcotic Drugs and Psychotropic Substances Act, to direct remand of that person further, and has to grant him bail, subject to the condition that after grant of bail, he furnishes his bond. Now, my lord, here in this case, as far as I am concerned, the prayer was dismissed for default, but at the same time, there was a default on the part of the investigating officer to also comply at the last chance. On 23rd August, again, it is posted for 15th November 2011. On 4th November 2011,
By your conduct, you were ratifying the conduct of the IO. IO is not submitting, you are also not pressing.
not, my lord, it is a default. It is a case of default. Default on the part of the learned counsel, my lord. I cannot make a comment
Yes.
further on this.
Don't.
And my lord, for 15th November 2011, my lord, immediately thereafter, on the next date itself, my lord, I will show to your lordship. On 4th November 2011, the application, the charge sheet is submitted by the investigating officer. And on 15th November 2011, my prayer for discharge is rejected by the learned magistrate on the ground that has submitted the report according to the order of the court. Now, my lord, I am principally on the following, my lord, before your lordship.
Yes.
Criminal manual. My lord, will first see that
Do
the
you have,
honorable division.
Mr. Chaudhary, do you have CFDC with you?
Yes, madam.
Could you please come down to subsection 5? There is certain interesting things.
Yes, madam.
Yes. I don't know. Yes, you just read it.
My lord, I am first reading the principal section, then I'm, my lord, placing the West Bengal amendment for you, lord. Whenever any person, my lord, this will not have much relevance. I am straight away coming to the West Bengal amendment.
Right.
But
Yes,
that would be
there is
more relevant.
Yes.
In its application to the
No,
state,
it's okay.
state of West Bengal,
in
section 167 of the Code of Criminal Procedure, 1973, in subsection 2 in the proviso, for clause B, the following clause shall be substituted. Namely, no magistrate shall authorize detention under this section in the police custody unless the accused is produced before him in person every time till the accused is in police custody. In the judicial custody, unless
accused is produced before him either
in person or through.
Hmm.
No, my lord,
or through medium of electronic video linkage.
no, my lord, there is another. This is one block of amendment. There is another block of amendment. My lord, will see immediately preceding that. That is, yes, that is the relevant amendment. My lord, this is an amendment of 1988, West Bengal Act 24 of 1988.
Yes.
I was reading till now, my lord, West Bengal Act 20 of 2004.
Yes.
Now, my lord, here in the first block of amendment 1988, in its application to the state of West Bengal, in
Yes, come to that.
Yes, my lord, the third clause shall apply. Any case other than those mentioned in clause 1 and clause 2.
It's a case under section 409.
Yes.
So I think subject to correction, of course, I.
My lord, this is under chapter 18. If I'm not wrong, II would be chapter 18. Subject to lordship's kind.
Yes, chapter 18. Yeah.
My lord, it would be 467, 460.
Any case exclusively traveled by Court of Sessions or a case under Chapter 18? No, or a case under Chapter 18 of the Indian Penal Code. The investigation is not concluded within a period of 3 years. Any case exclusively tribal by the Court of Sessions, 409, is not a
Yes.
magistrate tribal case, perhaps.
No, the sessions tribal, even if my
In
lord,
that event, the limitation is 3 years.
even if 3 years, my lord,
Yes.
then my lord also, I was arrested and produced on 4th July 2007.
7,
The
right?
first prayer of the investigating officer was made on 13th September 2010,
So after a lapse of 2 months.
after 3 years. My lord, let us keep it within the domain of the statute, 3 years, after 3 years, after completion of 3 years.
Yes.
My lord, lordship had rightly, we all get enlightened by your
No, no,
lordship.
no.
My lord, lordship has rightly pointed out this. So even if 3 years,
Hmm.
then also 13th September 2010 is after the period of 3 years.
Yes.
Now, my lord, I will produce before your lordship, my lord,
Hmm.
some judgments of this the honorable division benches of this honorable court
Hmm.
to show to your lordship the development which has taken place in respect of 167 subsection, the law 167 subsection 5. Now, my lord, this is will be by the public servant. This is even otherwise also. My lord, it is pending before the ACJM Uluberia. In
ACJM
regular code of criminal procedure, it is magistrate trial under the regular code.
Who is this?
However, there is a West Bengal Criminal Law Amendment Act in respect of. Even if we take it as accept it as 3 years also.
It is
My
pending
lord.
before learned decision because of
Yes, the charge sheet and.
yes, commitment is yet to. It should have been transferred to with the submission of charge sheet.
After submission of charge
Yes,
sheet.
yes. It should have been transferred to the special court.
My lord, kindly cease এগুলোর extra copy কোথায়? আমি যেটা যেটা চাইবো বলবো।
Mr. Chaudhary,
My lord. Yes, my lord, it will take.
no, I have to attend a division bench
Oh.
at 12.
My lord, I will come back tomorrow.
So better you come back tomorrow.
Well-
Today, actually, there is,
Lordship.
it's better your matter, it has
My
been
lord.
otherwise settled.
Yes, yes.
So let me utilize that
Take-
time,
take
come
that,
back tomorrow. You have come back early? Oh. No, I was told that by 10th of May. Yours is item number 18. No? Yes, thank you. Hopefully, from, no, I don't think it will continue beyond the lunch hour. Today, fourth, there is a possibility I will not be able to take up at 2. From 2 onwards, perhaps, that is the understanding, I don't know, let's see. But today at 2, I will be able to attend the court. Yes. 18,
Like
compromise.
This is a proceeding under section 138 of the Negotiable Instruments Act.
Hmm.
I was convicted by the learned magistrate. Subsequently, the conviction order was affirmed by the appellate court. In the meantime, I have paid the entire amount. Well, in
You have
year
paid the
2000
entire amount and it is accepted by,
Yes, it is accepted. Well,
who is,
there
you are
was-
representing?
Yes. Well, kindly take up PAN number 3 first, because this application was dismissed for default on September 7, 2021. Well, because of this dismissal, police went to my place, then I came to know that this application has been dismissed for default. Well, at page 16. PAN number 3, page 16.
3 or 2?
PAN number 3.
Where is your PAN 3? Yes. Page 16.
Page 16.
by my Lord Justice Ghosh, it was dismissed for default. My lord, this is the restoration application.
Yes.
But since there is a delay, my lord, trend number 2 is the section 5 application for condonation of delay. My lord, there
Delay
I
of
have
how many
explained
days? Delay of how many
delay
days,
of-
Mr. Sen?
$572. Well, paragraph 12.
572 days?
Yes, paragraph 12, page 8.
Okay.
Well, I've explained the delay from paragraph 7 onwards. 6 onwards, page 6, paragraph 6 onwards. Well, the advocate on record was suffering from flu-like symptoms during that COVID period. And ultimately, I came to know on 2023 when police went to my place in search of for execution of the warrant of arrest.
And
And while at Cran 1 is the
let us go one by one. Heard Mr. Sen, learned counsel for the petitioner, and Mr. HON'BLE, learned counsel representing the appeal. Stop. This revisional application was filed challenging the order passed in criminal appeal number 32 of 2009, thereby affirming the judgment and order of conviction and sentence passed by learned 10th Court of Metropolitan Magistrate in connection with C 8479 of 2004. The petition was This revisional application was dismissed for default on 7th of September 2021 during COVID period.
yes, not during just after reopening. Just after the Delta wave, second wave.
It is contended that the petitioner came to know about the order of dismissal only after police knocked his door pursuant to the direction of learned court. Stop. It is submitted at the bar that the petitioner, who has been suffering order of conviction, has paid the entire amount to the opposite party. Under such circumstances, having found the inaction on the part of the petitioner has been properly explained, I am inclined to condone the delay and restore the application to its original file. Stop. Does plan 2 of 2023 and 3 of 2023 are disposed of. Now next.
Now, my lord, kindly turn to page 21 of Trend 1.
Yes.
Right,
It
this
is-
is the money receipt.
It is submitted by Mr. Sen, learned counsel for the petitioner, that a sum of rupees 1,20,000 in compliance with the direction of learned trial court has been paid to Mr. Lokhinarayan Singh,
Paid by Mr. Lokhinarayan Singh, the petitioner, paid to the Sriram
sorry.
Finance Limited.
Lokhinarayan Singh is
Is
the,
the petitioner,
yes, the amount
the convict.
has been paid by Mr. Lokhinarayan Singh in favor of Sriram Finance Limited, which has been acknowledged by the company. Okay. With a receipt number.
Well, next
No.
next is the typed copy.
Yes, yes. acknowledged by the company on 27th of March 2023.
Number CALC 22303,
Number,
capital CALC.
yes, CALC 223032 70021. And what is this 40,000?
Well, this was the direction of this honorable court to deposit before the learned trial court for the grant of stay. Well, that order your lordship will find Cran 3,
Fine,
page,
is it relevant?
page 12.
Is it relevant?
No, well, that amount may be returned to the petitioner.
It is further submitted by Mr. Sen that pursuant to the direction of this court, while
10th
granting,
July 2012.
while granting stay of the impugned order, a sum of rupees 40,000 was deposited with the learned trial court. Stop. The petitioner is now seeking leave to withdraw the said amount, stop, which is considered, and the prayer is allowed. Learned trial court is directed to refund the amount of rupees 40,000 deposited on 28th of September to 2012 to the petitioner Lokhinarayan Singh on proper identification, whatever stuff. Since the parties have settled their dispute out of court, I do not find any reason to stand in the way. Out of court and terms of compromise are otherwise valid and lawful, comma, I do not find any reason to stand in the way. Stop. The impugned judgment stands quashed in view of the settlement arrived at by and between the parties.
Well,
With
warrant
this,
of
the
arrest,
petitioner-
if any, may be recalled. Well, warrant of arrest, if any, is pending. Well,
Okay.
police is running after me.
Warrant of arrest, if any, already issued by learned trial court, stands. What should I say? Order issuing the warrant of arrest by the learned trial court, if any, stands quashed.
Deeply. Deeply.
The copy of the order should be sent down to learned trial court for information and necessary action, blah, blah, blah.
Parties to act on this out.
Yes,
Parties
yes,
to
yes.
act.
Parties are, look. Parties may act upon the server copy of this code duly downloaded, blah, blah, whatever.
Deeply.
Thank you.
Deeply.
What is your matter, Mr. Gupta? Mr. Ganguly is also there, but the difficulty is I have a division bench.
We have no problem because my matter is 19 and 20. I was praying for adjournment.
Fine.
Well,
Then suggested it.
may a direction be passed for me to serve because
Okay.
very old matter. And after vacation. in India.
After vacation. Heard Mr. Gupta learned counsel for the petitioner. Who is seeking an accommodation. The matter is adjourned to appear on, say, 8th of June. 8th of June under the same heading. The petitioner is directed to serve upon the opposite party, indicating the date of hearing.
Great. Great.
Your matter? Tomorrow. So. Okay. Anyone seeking adjournment? Yes,
Item
very much interested.
item
Yes.
number 51, my lord.
Item number,
51. It is
51.
appealing.
I will come back at 2.
Lordship,
Very good.
item number 5, your lordship had passed over, made
5,
next week
yes.
or after the vacation as your lordship. please.
After the vacation, why?
Maybe after next week, my lord.
Very well, not this week.
Item 7 also, my lord, I'm for the petitioner.
Yes, there is nothing you, at your instance, I fixed 1st of May.
Yes, my lord, we'll do the matter.
You didn't show your face yesterday.
No, no, last occasion appeared, my lord.
Last occasion was
But
21st of April.
it's today, my lord.
No,
Yes,
what is the number?
my lord, 4048,
4048.
Shodhikari.
It's not before me. যাই হোক, এগুলো not today.
Not today, sir. Seven, not today, my lord. Okay.
Tomorrow.
Tomorrow.
Excuse me for the day. I have division bench
Yes, well,
matter.
I will do the matter.
I will come back at 2 hopefully. If anything exigency is there, you come back.
Hey, 1131.
Yes. সেদিন যেগুলো for the state. Wife is having an exam, so this is the 8th adjournment. All the time you appeared, sought for adjournment, and you assist. Sit down. After half an hour, I will take up your matter. Go through the record. Yes. Call the next one. একটা তো ওরা রেডি আছেন, দেখে দিন লিস্টটা দেখে দিন।
This is that matter, my lord. Conviction was under section 304 part 2. My lord, I have submitted
Yes.
before your lordship. My lord, I have nothing to argue on merit because my lord, I don't find anything to argue. The only prayer, my lord, I made before your lordship is that, my lord, this person is in custody for 3 years, 8 months almost. My lord, if this, my lord, this can be considered favorably, in view of that, my lord, we are ready to pay 50,000 rupees. My lord, it was your lordship's desire to make it 1 lakh. My lord, I have tried my level best. My lord,
No, I made it clear. So far the compensation part is concerned. Better you talk to Mr. Gupta
Mal-
and
Mal-
come to us.
I had a talk with Mr. Gupta also, but regarding this. On the last occasion, my lord, they came before your lordship. My lord,
Yes, that I know.
was really poor persons, my lord. An unfortunate incident has happened, my lord, that's true, but my lord, they are not in a position, especially when the earning member is already in custody for so many days.
And the bread earner has lost his life.
My lord, that's true, both sides, my lord.
In both sides, you were.
On one side, my lord, one male member will never return. On the other hand, my lord, this male person may return, subject to your lordship's blessings, but my lord,
Blessings. Don't make the court. Now you are drawing up simile between Godman and the court. Huh?
we address your lordship as
That's a
my lord.
dangerous proposition.
Actually, I believe my learned friend is saying that there's not much substance in the appeal. So
Yes,
we are left with
That's true.
lordship's blessings.
That's true. I made it clear on the very first day.
Okay, there is direction to pay rupees 5,000 to the victim, Muklema Bibi.
Yes, she was the injured,
She was the injured.
and 20,000 to the family members of the deceased.
Widow of the deceased.
Right.
So we can interfere and enhance it to the tune of rupees 40 plus 10, Mr. Gupta. 40,000 and 10,000, just double the amount.
My lord,
Direction upon the
Accused.
appellant, accused.
Appellant.
And the rest part is 357A.
357A, my lord, what I checked is that the amount for West Bengal for death is 2 lakh rupees. Is 2 lakh rupees.
Can it be awarded by the court or
Yes,
to be
yes.
decided by?
Yes, not only that, my lord can, this is lordship kindly sees that this is the minimum amount. 2 lakh is the minimum amount. Therefore, lordship can, this is the schedule, can award 3.5 lakhs and 50,000 here, that would cover 4 lakhs. That is the minimum amount.
acid, physical abuse of minor, rehabilitation of victim, death, 2 lakhs. Now, can it be awarded by the court?
Yes, yes, that is settled. It not only can be awarded by the trial court, but can also be awarded by the appellate court.
Under the POCSO Act, yes, there is a provision, clear.
Yeah, under 357A also, my lord, that is settled.
বই আছে একটু?
My lord,
357, capital A. Every state government in coordination with the central government shall prepare a scheme for providing fund for the purpose of compensation, whatever recommendation is made by the court for compensation. Subsection 2,
3, kindly comes to 3.
3.
If the trial court at the conclusion of the trial is satisfied that the compensation awarded under 357 is not adequate for such rehabilitation, or where the case end in acquittal or discharge and the victim has to be rehabilitated, it may make recommendation for compensation. So my lord, if the trial court can give this, High Court
Yes.
obviously as a continuation of the trial can award.
Yes.
So, my lord, the direction will be upon the SLSA, State Legal Services Authority.
This is minimum. This schedule is
Is minimum. No upper limit is given.
Aditya, ওই কে আছে? Take the- oh. Heard Mr. Shomojit Das Mahapatra, learned counsel for the appellant. Mr. Kaushik Gupta and Ms. Shayanti Shatra, representing the de facto complainant as well as the victim, being appointed by State Legal Services, Calcutta High Court Legal Services Committee. Yes, and who is for the state? None.
Trina Mitro. I'll inform her. Trina, phone kar.
And Miss Trina Mitro, learned counsel for the state. Trina Mitro. punishment. Stop. The sense of justice as perceived by the victim, as perceived by the family of the victim, as well as society at large, is bound to get hurt if the appellant is allowed to walk out of the correctional home, having spent only 3 years, 8 months out of 7 years. Stop. Where the accused person has been found guilty to the charge under section 304, part 2 of the Indian Penal Code,
As well as
part 2, Roman 2,
as well as 323. 323, 447.
as well as for committing offense under section 323 and 447 of the Indian Penal Code. So, it can safely be said that there is no premeditation on the part of the accused. Stop. Under such circumstances, I am of the view that instead of sentencing, instead of asking the accused person to undergo imprisonment for 7 years, ends of justice would be met if he is sentenced to suffer imprisonment for 5 years. ওর আগে একটু লিখে দেবেন, considering the age of the accused and his financial consideration doesn't come on the
Past
way.
antecedents.
Yes, and his criminal antecedent, as well as the responsibility he is supposed to shoulder towards his family. Does he have any child?
3. That responsibility, my lord,
Three
he took
children.
very serious.
3 children. Is it about?
My lord, on the last occasion they came, my lord, I didn't ask for their age, but my lord, around 9, 10, 7 to 10.
কি বলে? ওটা shoulder. Shoulder the responsibility towards his family. I'm of the view that ends of justice would be met if he is sentenced to suffer. Ends of justice would be met, MET, if he is sentenced to suffer rigorous imprisonment for 5 years instead of 7 years. Stop. The accused person is further directed to pay a sum of rupees 10,000 towards compensation to the victim Muklema Bibi and rupees 40,000 to the widow of the deceased Rafiqul Sharkar under section 357 of the Criminal Procedure Code. Stop. It is submitted by Mr. Gupta that considering the present day cost of living and the fact that the family lost their sole bread earner, this court should invoke the provision of section 357A of the Code of Criminal Procedure and award a further compensation under the Hey, about further compensation. Stop. State is not,
She has not come to court.
then I should not record his presence.
Not record her.
Trinamitrata কেটে দেবেন, হ্যাঁ?
সঙ্গে নিশ্চয়ই কেউ একজন
ওই
senior- না সিনিয়র তো কেউ নিশ্চয়ই
Who can represent the state? বিদ্যুৎ রায়, এই আদিত্য বাবু, স্টেটের কে আছে বলুন তো, এক কাজ করুন, একটু সেন্স, ওই বিশ্বাস আছেন আমাদের, শ্রেয়সী বিশ্বাস আর অনুসুয়া সিনহা, এরকম কাউকে একটু যে আছেন একটু ডেকে নিন। হ্যাঁ। একটু একটু কিউটা দিন আগের সেন্টেন্সটা। মিস্টার গুপ্ত। হ্যাঁ। হ্যাঁ। Day cost of living. Bread earner. Invoke the provision of section 357A. Further compensation. To the tune of rupees 3,50,000, as the family is badly in need of financial rehabilitation. I find the submission made by Mr. Gupta is justified, and in order to ensure a dignified life of the family members of the victim, of the deceased, Rafiqul or whatever, a sum of rupees 3,50,000 should be awarded towards the rehabilitation of the financial rehabilitation of the family. Accordingly, I direct the Secretary, State Legal Services Authority to grant a sum of rupees 3,50,000 under the West Bengal
Victim compensation scheme
under the West
2017.
Bengal Victim Compensation Scheme 2017 within
Within a period of, my lord, 2 months, they will
Within-
need this time.
within a period of 2 months from date. With this, but I need to pass an order, or this will do.
No, this will do.
This will do.
This will, only,
With this, yes.
only thing, my lord, with regard to the 50,000 that the accused is going to pay, whether my lord would consider any in default clause. Because if they do not pay, then
Then, no, you pay by
my lord,
7 days.
that my lord, at the time of release. Subject, my lord, your lordship gives this right.
No, you pay and appear before show the document before the learned trial court, then only release order will be issued. That
Yes,
I am
my lord.
indicating.
Yes, this
That-
rider must be.
yes, my lord, yes.
And my lord, one thing, my lord, they are getting 3,50,000 from state.
Yes,
My lord, that the deceased family is getting 40,000 from me. This comes to 3,90,000. My lord, let it be, since Muklima
4 lakh,
no,
10,000 to the.
you are giving 10,000 to the injured,
to the injured Muklima.
Muklema,
And deceased family,
40,000.
40,000. My lord, what I propose, my lord, since Muklima is alive, my lord, and she didn't suffer any serious injury, let it be 5,000, and for them 50,000. Your lordship is giving me part
55.
of 45,000. I am taking it as 55,000.
Okay,
Then my lord, it will look better.
okay.
That at least.
ওটাকে ঠিক আছে, ওই আগে এটা শেষ করি তারপর বলছি। The compensation amount to the tune of rupees 55,000.
No. For Muklima, your lordship has.
In
has
all,
directed
in all,
Total.
total 55,000
Total 50.
to be to be paid on behalf of the accused persons. By এটা গোলমাল হলো anyway এটা আমি পরে correction করে দেবো by 12th of May
April.
May today is second
মানে very poor value, মানে give us at least 1 month. মানে they will need this
okay
this time.
it
They are
is
not
submitted
going
by Mr. Das Mohapatra that 1 month's time should be given to the accused person to deposit to pay the compensation directly no
to the judicial case. Before
then again
before the learned
if you
trial.
deposit in the court the difficulty is again you know what I don't want to utter you send it to their bank account no
Absolutely.
issue if you don't want to
Absolutely.
pay them by cash and produce the receipt before the learned trial court.
তোমার মক্কেলের ইয়ে নেই ব্যাংক অ্যাকাউন্ট হতে পারে এরা এরা যে জন থেকে এসেছে
To the victim and the widow of the to the victim Muklima Bibi and the widow of the deceased directly to their bank account. Start. Mr. Gupta, we are yes, madam, there is serious issue. Mr. Gupta, then when we are reducing the period of imprisonment by 2 years only, then why default clause?
No, the default clause, the reason being, my lord, in the event he does not pay 50,000, then what happens?
Then 7 years.
Then it will become 7 years.
This contingent order will create trouble. So this rider should be there. Only what I was thinking that since I still have 1 year, 4 months to serve out. At the time of release, I will pay. This submission I am making only because I have seen the standard from which
Should it be
the financial
reduced
standard.
to the period already undergone?
Well, that as it has fallen from your lordship, be very candid. They are not in a position to pay higher compensation. And at 5 years in a 304 part 2 case
Is quite reasonable
is
on the lower side.
on the lower side.
Yes.
Because it can be 10 years or more. So 5 years, at least 5 years,
up to 10 years.
up to 10
Up to
years.
10 years.
So at least
It can be extended up to that. Though there is no rule, not in your case, in other cases, it could have been. So very well, you pay, you should,
I'll arrange.
otherwise, in default, the benefit of reduction of period of sentence by 2 years will not be made available to the accused person.
my lord.
You pay within 4 weeks or forget about the reduction by 2 years.
As a lordship.
Anything that he will have to buy his way.
No, আর কি হলো, হ্যাঁ। With this, the criminal appeal is disposed of. খালি ওই তৃণামিত্রর জায়গায় অনুসুয়া সিনহা লিখে দেবে। I hope this will do.
My lord, my lord.
Thank you.
My lord, and
মাঝখানের প্যারাটা দেখে নেবো, আচ্ছা দেখুন আপনি এটা টাইপ করে দিন আমি দেখি।
and my lord, one sentence, my lord,
Yes.
that Ms. Shayanti Shatra is directed to communicate this order
Yes,
to the SLS, Secretary SLS.
yes, Miss Shayanti Shatra is directed to communicate this order to the secretary, member secretary, State Legal Services Authority, West Bengal. for information and necessary action.
Great.
This is your,
Created a compilation of
yes.
all,
No, it is very useful at times.
yes. Victim compensation scheme of all over India. Grateful.
Thank you.
Deeply impressed.
देखिए you are representing the respondent.
I am for the appellant.
You
that
are
is
for the appellant. Yes.
complainant.
You are for the appellant complainant.
Yes. This is a case of acquittal under section 138.
130.
Appeal against acquittal.
Very good. Tell me.
May I start, my lord?
Yes.
My lord, the appellant Deepak Kumar Shaw was pleased to file a complaint under section 138 of the Negotiable Instrument
It
Act
was his
against Union
pleasure.
Day.
It was the pleasure of the complainant to file the case.
No,
Anyway, you continue. Yes.
I did not say that.
Yes, you
The
continue.
complainant was pleased to. Sit down. An criminal complaint under section 138 of the Negotiable Instrument Act against one Showman Day and one Paramita Day. My lord, I was only searching the record as to see why Paramita Day was being recused from this case. I do not know why. Because she did not face the trial, I find. That is, I was trying to find out that order.
Where is your petition of complaint? Did you?
Yes, my lord, it's at page 1.
Page 1 of the
Petition of
paper.
complaint, my lord, page 1. Yes, inner kindly says there are again there is page 1.
Yes.
My lord. So
Physically.
it was against Showman Day and one Paramita Day. Husband and wife.
Yes.
My lord, may I read the relevant portions of the complaint? My lord. My lord, kindly comes to page 3. The accused number 1 was the owner of the premises number 48 Hidaram Banerjee Lane, Kolkata, was in respect of the 50% share and with a definite malafide intention in his mind executed a deed in favor of his minor daughters. Ms. Deepanita Day and Ms. Nonita Day duly represented by their mother. Mrs. Paramita Day, whatever, my lord. The accused number 2 took a loan of rupees 8,60,000 in different installments during the period from 6/4/2002 to 28/10/2002 with several commitment, either severally or jointly with her husband. Number 1, to pay back the said money to your petitioner within some specified period of time, but neither of them kept their commitment. That thereafter, on being chased by the petitioner, the accused number 1 issued a check. Accused number 1 issued a check. This is paragraph 5, amounting to rupees 8,60,000 by check number this, dated this, drawn on State Bank of India, East Connect branch on behalf of his wife, that is accused number 2, in favor of your petitioner in discharging their liability towards the above accommodated by the petitioner to the accused persons. That thereafter, your petitioner deposited the said check to his banker, State Bank of Hyderabad, Sarat Bose Road, branch, lastly on 17/4/2003. But unfortunately, the said check was returned unpaid by the drawee on 21/4/2003 with the comment insufficient fund. That thereafter the endorsement of the insufficient fund. Thereafter your petitioner served a notice upon the accused persons on 29/4/2003, that is within 9 days. Through his learned advocate, Ms. Shomila Nath, by registered post with AD, and the accused persons received those notices on 30/4/2003 and 1/5/2003. So that was also within time. But thereafter your petitioner waited so long for the receipt of payment in lieu of the above dishonored check, but no effect to that effect. This is the complaint. Now let us come to the my lord essay. That is at page 2. Kindly come to the inner page of the complaint. I have registered this case against Showman Day and Paramita Day, the two convicts, two accused. Two convicts borrowed rupees 8,60,000 from me. In exchange, they gave me a change check on 2/1/2003, which bears upon which bears number 612,517, dated 2/1/2003, and upon being an amount being 8,60,000. The bank being SBI Esmite branch. I deposited the check on Sarat Bose Road on 17/4, but the check was dishonored on 21/4/2003. Later, I sent notice to the advocate on 29/4/2003 through my advocate. And both the accused persons received the notice, but even after that, they never gave any reply. So that is the complaint. This is the solemn affirmation under section 200. Now let us come to the, my lord, the PW1, that is at page 6. PW1, page 6. My lord, I'm starting. I have lost this case against Showman De and Paramita De. I know the name of the accused number 2 Paramita De has been filed. Today, accused Showman De is not present in court today. This, my lord, the second line, I know that the name of the accused number 2 Paramita De has been filed. Well, this was filed by an order by the learned magistrate. I do not know the reason why it was the case.
Who issued the check? Your case is Showman, they issued the check.
Yes.
How could you implicate this lady?
Very well. Today, accused Showman De is not present in court today. If he had been present, I would have identified him. It is true that I have filed an application on affidavit dated 14/11/2021 before this court. This is the said affidavit. This is my signature. I have put my signature under after understanding its nature and contents. Accused Showman De gave me one check bearing number 612517. This is the said check. The check is an amount of ₹1,60,000. This should be ₹8,60,000. My lord, I have seen the exhibit. Issued on 2/1/2003, drawn on State Bank of India, Esplanade branch. I deposited the check on the State Bank of Hyderabad on 17/4/2003. This is the said deposit slip. But the said check was dishonored and was returned with the memo 19/4/2003 with the note insufficient fund. After the said check is bounced, I gave one advocate's notice to the accused on 29/4/2003. This is the said copy of the demand notice sent by me to the accused. I sent the demand notice to the registered post. This is the said postal receipt. I sent the demand notice to the accused, the two accused on the same date, that is 29/4/2003. But in spite of sending demand notice, the accused didn't return me my money. I received the two AD cards of the demand notices sent by me to the accused, showing that the notice was duly received by them. These are the two AD cards. I have filed this case before the court for not getting back my money. This is my said complaint filed. This is I put my signatures for understanding exhibit 9. This is the signature of the accused put upon the checks. The accused signed the checks in front of my eyes. Okay? That is the evidence matter. Now cross-examination at page 7. I have 3 taxis bearing numbers WB04E 1480, WB04T 7008, WB04C 2455. I am running this business since 1996. I am the owner of the above said 3 taxis. I bought this said 3 taxis first hand. Out of the 3 taxis, 1 taxi was financed by bank and the other 2 by private finances. The name of the private financer APG Finance and the name of the bank financer is United Bank of India. I cannot say the amount of EMI paid by me for the said 3 taxis. Presently, I have sold out all the said 3 vehicles at the end of year 2012. I have filed case against Showman De and Paramita De. I know these 2 accused persons since 1985 and 1986. I gave loan amount of ₹8,60,000 to accused Showman De. I have no money lending license. I gave the said loan to the accused Showman De out of good relation, and as because he has known to me since long, I gave the loan of ₹8,60,000 in cash in installments. I gave the loan at the end of the year 2002. I have the money receipts written by Showman De himself. Today, I have brought the said 3 money receipts. These are the 3 money receipts signed by accused Paramita De and Showman De. I know their signature. In the first money receipt, which is marked as Exhibit A, the loan was taken by accused Paramita De. No date of taking loan is mentioned in the money receipt, which is marked as Exhibit A. Out of the 2 witnesses on Exhibit A, 1 witness is Showman De. Showman De is the husband of Paramita De. No other person has put his or her signature as witness except Showman De on Exhibit A. On the Exhibit B, accused Paramita De has put her signature. In Exhibit B, loan amount of ₹2,40,000. Both of them jointly took the said loan. Cross-examination resumes. I demanded money from the accused persons, but the accused persons did not pay me back. I have not submitted any document before this court showing that I have demanded money from the accused persons. In Exhibit C, there is no date and money receipt. There are 2 witnesses in Exhibit C. Witnesses are not required. Hearing says voluntarily. I cannot recollect the dates of the money receipt Exhibit A, B, and C. I cannot say the exact date of making last payment. I have my PAN card, but at present I cannot say the exact PAN number. At present, I do not have my PAN card with me, but I can show a file. But I can show and file my PAN card Xerox copy before this court. I filed my income tax returns. I have not filed my income returns for the assessment year 2002 to March 2003. I started filing my income tax returns from 2004. I have my bank account at State Bank of Hyderabad, Sarat Bose Road. I cannot say the exact date or year of opening my said bank account. I cannot submit any bank statement, said account of mine at the said branch. It is a fact that as per declaration on the money receipt A, money receipt exhibit A deed of the accused has been kept mortgage. This is the said deed. The deed is exhibit D was not registered mortgage. The accused person told me that I shall surely repay the money, and as such, this is not required. No separate agreement was executed in respect to the mortgage of the deed between the parties. I have not filed any other case before the proper forum for realization of the loan amount. Not a fact that I have not given any such loan as alleged by me. Not a fact that I made the accused persons to put their signatures upon the blank paper and blank check. Not a fact that I have not given any loan to accused number one. Not a fact that I wanted to grab the money by using the blank check. Or oath is administered. Cross-examination resumes. I got rupees 8,60,000 by selling my cars. I cannot say on which date I sold my car. At present, I have forgotten the exact date of selling my car. I got the amount of selling my car in cash. At the relevant point of time, I sold 2 to 3 cars. At present, I can only recollect the name of Mr. Madan Hallar, to whom I sold my 1 car. I cannot say the address of Madan Hallar, who purchased my car. I sold my car in the year 2000. Not a fact that I did not have rupees 8,60,000 at that relevant point of time, and as such, I did not give any loan to the accused. Not a fact that I lodged a total false complaint. The deposition of witness number 2 for the this is witness number 2 for the defense. Well, let's come to witness number 1 first. Otherwise, my lord, that is the accused himself, Showman. Well, that is at page 16.
Yes, I'm on that.
Yes. No, this is my lord.
Page
This is
18.
313 examination.
You come to page 18.
Yes. Examination in chief of the Somen Das, examined as DW1. I am engaged with some part-time job like bookkeeping in contract basis. I do not know the complainant Deepak Shaw. He was known to my ex-wife. At present, my ex-wife does not reside with me. We have been divorced from each other since the year 2006. The dispute between me and wife started from the year 2001 with objection. I have not taken any loan of rupees 8,60,000 from Deepak Shaw. I have no liability towards him. I have taken information regarding the vehicles numbers from Motor Vehicles Department situated at Biltala, from whereby I came to know that no such vehicle was at all sold by the complainant as stated by him in his deposition. This is the details of the vehicle being WB04E1480 obtained from the Motor Vehicles Department, Kolkata. This shows that the vehicle bearing the said number is owned by Prithpal Singh, and this particular vehicle number was stated by Deepak Shaw in his deposition before this court. It is bearing the seal and signature of the issuing authority of the Motor Vehicles Department, Kolkata. This was issued on 22/4/2013, and it also shows the year of manufacture as 2009, marked as Exhibit E. This is the particulars of the vehicle bearing number WB04C2455, obtained from Motor Vehicles Department, Kolkata. This shows that the said vehicle is owned by one Parvez Alam, resident of 14 Kovis Road, Shibpur. It also shows that the vehicle was manufactured in the year 2004. It also bears the seal and signature of the issuing authority of the Motor Vehicle Department, and it was issued on 22/4/2013.
Yes, you carry on.
22/4/2013. No information has been received regarding the vehicle being number WB04P7008 as stated by the complainant before this court, as because no documents are there regarding the said vehicle in the Motor Vehicle Department of Beltala. Normal cross-examination. I cannot say anything from these documents marked as Exhibit E and F, and who sold the said vehicles bear the said number to whom and on which date. Dipanita De, Ronita De are my daughters. It is fact that in the year 1919, my said daughters were minor. It is a fact that I gifted one property measuring more or less 1 quota 13 chatak at premises number 48 Hidanam Banerjee Lane by virtue of deed of gift to my daughters, dated 6/7/1999. It is a fact that I have represented my said 2 minor daughters in the said deed of gift. The said deed of gift was registered it was registered at Additional Register of Assurance, Kolkata. I have put my signature upon the said deed of gift as owner. It is my signature. It is a fact that signature upon Exhibit A as witness is of mine. It is a fact that signature upon Exhibit B is also of mine, but I cannot say that whether signature upon Exhibit C is of mine or not. It is a fact that at the time of execution of the said money receipts and deed of gift, Paramita De was my wife. Oath is administered. Signature Exhibit upon exhibit 2 is of mine. My name is written as witness upon exhibit A, but it is not in my handwriting. It is a fact that in the year 2002, 2003, my daughters were minor then. Not a fact that I was the custodian of the property related to the said deed of gift, which has been marked as exhibit D herein. Not a fact that I kept the said gift, deed of gift as security to Mr. Deepak Shah in lieu of the loan taken by me from him. The said deed of gift was kept as security by its custodian, who is accused number 2 is my ex-wife. It is a fact that if anyone takes a loan from another person, then it is his liability to repay the loan by means of check or cash. It is a fact that I received the demand notice sent by learned advocate of Deepak Kumar Shah. The fact that even after receiving notice, I have not replied because I had no liability to repay the amount in the alleged check. My ex-wife said that she will take care of the matter. It is a fact that in the year 2003, marriage was subsisting between me and Paramita De. I cannot recollect that whether any documents has been filed by me before this court showing that we are divorced from each other. Not a fact that I issued the alleged check in discharge of my liability and debt. Not a fact that whatever I have stated before this court, I have stated falsely. Some blank stamp papers and checks signed by me were kept in custody of my ex-wife. It is a fact that all documents, checks, etc. that were used were in the year 2003. I have not lodged any complaint diary before the local police station stating that the blank checks and stamp papers bearing have been used by my ex-wife. I think it would be shown. It is a fact that I have not paid for issuing any such warrant before the court for recovery of the said blank checks and stamp papers bearing my signature that were in the custody of my ex-wife. This is because my ex-wife stated that she will look after the matter. This is my lord the evidence of DW1. Let us come back to DW2 and DW3.
Yes.
That is at page 11. Witness number 2 for the prosecution, Devabrata Chatterjee. I have come to depose before the court after receiving summons from the court. I have been authorized by the Secretary RTA, Kolkata region.
No, how it is relevant?
Not relevant. Absolutely not relevant. I have to read the entire evidence, so I am reading it because otherwise my learned friend will say. Because my lord, 138 of the Negotiable Instrument Act says that if a check is issued.
So you come to that point.
Yes, my lord. This I just in one line, Devabrata Chatterjee's evidence is here, and also the evidence of the Devashish Patra, who is also from my lord, manager of Hyderabad.
Chief manager,
Yes,
State
manager,
Bank.
Hyderabad. My lord, 130. What I need to submit is that 138 of the Negotiable Instruments Act speaks about a prior presumption of law under 139. If a check is being issued, it is presumed. The court shall presume that it is because of in discharge of some legally enforceable
Fine, fine.
part and whole.
Yes. Now you.
And the accused can rebut. It is rebuttable, and the accused has to rebut by shown that either he doesn't
Yes,
have
now,
any debt.
now take me to the document to substantiate that you paid the money to the accused person.
My lord, here and where I will just submit. My lord, I will just submit one thing.
Yes,
That with what is my source of income?
I am not on that.
And whether I have submitted with the proper receipts or not is not of much importance in a case of 138.
Fine.
It is when I have given a check has been issued, it will be presumed that it was presumed for one legally enforceable debt or
Do
liability.
you think so
My lord,
really?
may I complete my
Do you think so really?
my lord?
Do you think so? Mere issuance of check will absolve you of the liability to show that yes, he has incurred a legally
My lord, may I
Yes,
complete my
yes.
lord? May I complete my lord? Legally.
you have to prove, so
Yes.
far my understanding goes, subject to correction, that yes, your the person who has issued the check
My lord, he has
has
proved that he has.
incurred liability. And in discharge of that liability, check was issued.
Yes.
So your onus is to prove that there was liability. And the issuance of check lead us to the presumption that the check was issued in discharge of that liability. Subject to correction, of course.
Yes, my lord. First of all, my lord, may I submit?
Yes.
That under section 139 or section 138 of the Negotiable Instrument Act,
Yes.
nowhere it postulates that
Please read for all of us. NIF.
my lord,
Hey, Aditya Babu. Hey, page.
My lord,
Please read once for all of us.
yes. I will come to 138 of the negotiable instruments act.
Yes.
Dishonor of check for insufficiency of fund, etc. of funds in the account. Where any check drawn by a person on an account maintained by him with a banker for payment of any amount of money to another person, from out of that account account for the discharge in whole or in part of any debt or other liability.
Go a bit slowly.
Yes.
This is the important
Yes.
phrase. Yes.
I'm repeating it.
Come
once.
again.
Yes. Where any check drawn by a person
Hmm.
on an account maintained by him
Yes.
with a banker for payment of any amount of money to another person from out of that
Account.
for the discharge in whole or in part of any debt or other liability is returned by the bank unpaid, either because of the
so,
amount
sir,
of money standing to the credit of the
What
account.
is, what
is-
is
is-
what is the important portion underscored, to be underscored, is that for discharge in whole or in part of any debt or other liability.
Yes.
So you have to show that, yes, there exist certain
Yes,
liabilities,
yes,
certain debt,
Yes, yes.
and in discharge of that, once the check is issued, it is to be presumed that in discharge of that liability, this check was issued.
Yes, my lord. My
There
lord.
will be
My lord.
no
May I-
other way.
My lord, may I submit?
Yes,
139, kindly comes to 139 negotiable.
very well.
It shall be presumed,
Yes.
it shall be presumed,
Hmm.
unless the contrary is proved,
Hmm.
that the holder of a check
Hmm.
received the check of the nature
Hmm.
referred to in section 138 for the discharge in whole or in part of the debt or other liability.
So it comes back again.
Yes.
You need to prove there was
Yes.
liability,
Yes.
and
yes,
it is to
yes,
be presumed
yes,
in
yes, I'm
discharge of
coming to that, I'm
liability,
coming to
check
that,
was
I'm
issued.
coming to that. I understood your lordship.
Yes, yes,
My lord, kindly comes to section 118.
118. Very well. These are all now settled principle of law, sir. Tell me.
Presumption as to negotiable instruments.
Yes,
Until the contrary is proved, the following presumption shall be made of
Yes.
consideration that every negotiable instrument was made or drawn for consideration, and that every such instrument, when it has been accepted, endorsed, negotiated or transferred, was accepted, endorsed, negotiated, or transferred for
Yes.
some consideration.
yes, there is no
B.
conflict.
As to date, as to time of transfer, as to order of endorsement, well, this is there. Provided.
There is no conflict. It is to be presumed.
Yes, it is to be presumed.
Yes.
My lord, when a check the accused has submitted, accused has to put before the court whether she has lent the money or not.
Sorry. First, you were to prove that there was liability.
My lord, I am not, I do not have that burden on my shoulders. I have to only show it to the court that I have.
Okay, you
extended
carry
the-
on. Okay, you
Yes,
carry
I
on.
have extended the loan. I have said.
You have to prove that you have extended the loan. That is what I am telling you.
My lord, I
First, you
understand.
show that the gentleman, the accused, borrowed money from you. Only that part you are to discharge. Once you discharge this, the other person
My lord,
is to shoulder
Then
the
I have-
responsibility
I have
to
to-
rebut
my
this.
lord, my humble submission is that if I have raised before a court
Yes.
that I have extended him a loan, I need not even prove that how I extended the loan. I need
No,
not. even prove.
I am not saying how. I am saying you show that you have extended the loan, not how. I am not interested in how. I am interested in only the factum, yes, you lent the money, he borrowed the money.
Yes,
This
that is there,
fact.
because for that reason, he has issued the check. That proves that I have.
Again,
lent the money.
you are jumping the step.
My lord, that is.
For that, he has issued the check.
Yes.
For that, you need to prove. For this, the check was issued. And
Because of the
this,
loan, because I have said
that
several times in
loan,
my
that
evidence.
loan, you need to prove that, yes, I lent money. He
But how will I
took
prove
money.
that? You, my lord, just now say, my lord, it came from your lordship that how you don't have to prove.
How
But
you
I
have procured the money, I am not on that. I am not on your
Only that
source.
actually
Please
extension
listen to me
An
first.
extension of the loan.
Please listen to me first. I am not on your source of money.
No, I am also, I understand.
I only want to see that it is you who lent the money to this gentleman who issued the check.
Well,
It will serve the purpose.
My lord, in my humble submission, my lord,
Yes.
I need not, the
Very
order
well,
is not
then
on my.
proceed.
Yeah.
Fine,
I'm
fine,
just placing my judgment of the Supreme Court,
Fine.
my lord.
you give it,
Take minute, take minute.
give it to me.
Come on,
Then-
just a moment, my lord. Just a moment, my lord. Yes.
Tell me.
I will, in this case of my lord, it's similar case where the receipts and everything, the accused failed to prove that he had extended the loan, but the honorable appeals court held that he accused, the complainant did not prove anything. My lord, I'll talk.
Paragraph.
Yes, I am going straight away into the judgment, my lord, instead of the head notes.
No, no, head note will not serve.
Yes.
Tell me
yes,
the
yes,
paragraph.
Yes. My lord, I am coming, my lord, kindly come to paragraph 5.
Paragraph 5.
Yes. After
I'm
accepting the record,
afraid paragraph 5 doesn't.
my lord, I will go on. I have
It's-
several
it's-
paragraphs to show your lordship.
Okay.
I will start from paragraph 5.
Paragraph 5 is what the finding of learned trial court.
Yes, we have to see that it is false squarely in our
Okay.
case or not, similar case.
Okay.
After examining that record, the trial court found that the accused had admitted the signatures on the check and the reference to the decision of this court in Ranganagappa and Sri Mohan Ryu. Presumption envisaged by the section 138 of the negotiable acts. When I can come to 5.1.1. There are no document evidence to show the source of income for addressing the loan to the accused. That is not needed here.
No.
5.1.2. The complainant failed to record the transaction in the form of receipts, promissory notes, or even kacha notes. 5.1.4. The complainant had no knowledge about the dates and other particulars of such check.
Hmm.
Then my lord come to 5.2. The complainant failed to prove that he has extended the loan by way of the receipts or anything. In this case also, with reference to the aforesaid factors, 5.2, my lord. With reference to the aforesaid factors and circumstances, the trial court concluded that the accused was successful in bringing rebuttal evidence to the requisite level of preponderance of probabilities and observed that the complainant had failed to prove beyond all reasonable doubt that the check were issued in part payment of the loan of rupees 22.50 lakhs. Hence, all the 7 complaints cases were dismissed by the similar but separate judgments and order dated 9/2017. When now kindly come to paragraph 6. Against the aforementioned judgment, the High Court orders of acquittal, the complainant preferred the appeals before the High Court of Gujarat, which have been considered and decided together by the impugned common judgment dated 8/1/2018. The High Court observed that the presumption under section 118 and 139 of the Negotiable Instrument Act was required to be drawn that the checks were issued for consideration, and until contrary was proved, such presumption would hold good. That the complainant had proved legally enforceable debt in oral and as also documentary evidence, including the written acknowledgement by the accused on stamp paper, and that except bare denial, nothing was brought on record by the accused to dislodge the proof adduced by the complainant. The High Court observed that if the transaction in question was not reflected in the accounts, the income tax return, and that would at best hold the assessee or lender liable for action under Income Tax Act law. But if the complainant succeeds in showing that the lending of amount, the existence of legally
So, sir, please stop here.
yes,
This is what I am asking you. Complainant showing, read again.
lending of an account.
That is
Amount.
what you need to show this. That
Lending
is
of
what
account-
time and again I am telling you. You need to show that you lent the money, he borrowed the money. That's all. You don't have to show your source of money.
No, source of money, I'm
So
not.
you
that.
show me that money was lent by you. What is that document? You show me that.
My lord, in my.
Read
humble-
again,
I
read
have
again,
read it, my
please.
lord. My
Please.
humble understanding, my lord, that I have,
Why don't you read again? Come.
I have read it, my lord.
Read slowly, you will get to know.
But if the complainant succeeds in showing the lending of amount, that
Yes.
part,
So that is
Lending of
what,
amount.
that
That
is
is
what
my-
I am asking you. You show me that
my lord,
money was
I have-
lent by
in
you.
my evidence, I have stated I have given loan and.
Then
Showman
what
has
about
also accepted-
exhibit A?
Showman has accepted that my loan was taken. by
What
my wife.
about exhibit A? What is your exhibit A?
That is the receipt
Receipt issued by,
by Showman. Showman was the witness and.
please go
issued
through
by-
the document
Yes, issued by the wife.
issued by the wife,
Showman was the witness.
acknowledging
Yes,
the payment of rupees
40,000 something.
2,40,000.
No, first one was 1,60,000 and 2,40,000.
No, let's go revisit. It's dated 6th of April 2002. 6th of April 2002. Am I correct?
Just a moment, my lord. Oh, in the compliance evidence, no? My lord, page 9. It is a
Page-
fact that as per declaration, the money receipt exhibit A. a deed of
Exhibit
accused
A.
has been- no.
Exhibit A is the,
Exhibit A is the one of the deed that was kept as security.
okay, forget that.
Yes.
Then
My lord, kindly comes to page 8.
8,
Out of the two witness, exhibit A, one witness is shown there,
yes.
and exhibit B, the loan amount of 2,40,000, which
So-
is
so-
exhibit B.
So
Hmm.
it can be said that Paromita De acknowledged the receipt of rupees 2,40,000 as loan extended by you.
When in the receipt, the first receipt, the amount is not there.
Which one is first receipt?
Exhibit A. 2,40,000
Exhibit A is
B.
the, exhibit A, you just say it's a
Right.
declaration.
That is exhibit D. Exhibit A is the first money receipt, which doesn't mention any amount here in the evidence. Exhibit B is the second money receipt,
Exhibit A is the
first money receipt. Page
money
8,
receipt.
Page 8,
Acknowledging that she received a sum of rupees 6 lakhs.
acknowledging.
You read on the fourth line, perhaps, if I am not wrong. Fourth line of the instrument, declaration or undertaking, whatever you
Page
say.
8, my lord.
I don't know page 8. I am reading out exhibit A.
Exhibit A, I don't have a copy, my lord.
You don't have a copy. Then how could you argue without going through the documents reliable?
Actually, I was going through the record, that is why.
Then you should come prepared.
My
I'm giving my judicial time.
because my humble
You cannot in the midst of a hearing, you cannot say this.
my lord, my humble submission to the lordship is
Whatever
that
it is,
the accused, if accused,
whatever it is, sir,
my lord,
you
my
are,
lord, may I complete my argument? I
No,
will take
no.
only 5 minutes to complete my argument.
okay,
My
very
lord.
well, you complete.
My lord, my humble submission is that the accused needs to only place before the court that he has extended a loan. The receipts,
Accused.
I'm sorry, my the complainant, and he needs to place before the court that he has extended the loan. By this way, in this case, I only place before lordship that the loan was given to both of them, and Showman has also agreed that the loan was given to his wife, and for which he paid the check. Number one. Number two, a deed, which is their house, they had kept it as security, which all the more clearly shows that the loan was given. This is how I prove that the loan was given. Now, it is upon the accused. It is upon the accused to show to the court that the check that I had issued was only because for the payment of legally enforceable debt or liability. Only by finding fault in the prosecution case will not revert that liability.
Yes,
It will
I am
not
with you.
revert. It
I
is
am-
there in this judgment.
Yes, I am with you. Fine. I am with you on
Yes.
this.
Yes, my lord. Then the only thing is that he has to rebut that preponderance of probability by showing that I am supposed to only rebut the possibility that it was not issued for legally enforceable debt or liability. Or finding fault in the prosecution case will not help me in rebutting that. That is my first. Or I will have to show there was no debt at all.
Yes.
These are the two things. My lord, I will just place this judgment and I will finish.
Yes,
I am
yes,
not to know.
you proceed.
My lord, kindly comes to paragraph. This is the final judgment. My lord, kindly comes to page 113 of the judgment.
113
of the judgment of the Supreme Court.
Yes.
My lord, after the High Court also observed that the issue regarding the washing away of the checks in rainwater was of no significance when the accused was accepted his liability in clear terms. If the accused accepts his liability in clear terms, that is at page 6.1. That part. Yes. Now, my lord, kindly comes. Then the learned judge of the Supreme Court has mentioned a judgment in last line of the paragraph. Shashi Mohan Goenka case. My lord, kindly comes to the last line of that page. I am not reading the entire part. That is not relevant over here. It is to be noted that the respondent number 2, the last line, my lord, of that page. It is to be noted that the respondent number 2 has admitted his signature in the input check. In our case also, he has admitted the signature in his check. At no point of time the check was disputed. Once this fact is acknowledged that the signature on the check is that of the respondent number 2 accused, Section 113 of the Negotiable Instrument Act would mandate the presumption that the check concerned a legally enforceable debt or liability. Of course, this presumption is in the nature of rebuttable, and onus is on the accused, therefore, to raise the probable defense. So once he accepts the check, it is my signature and the check is there, it will be presumed by the court. The court shall presume that it was issued in lieu of a legally enforceable debt or liability. It is now upon the accused to show that no, that I have not issued this check for some other purpose, but not legally enforceable debt or liability in part or in whole, or he has to show that it was no debt at all. Now, my lord, kindly come to page paragraph 71 on the same page, 114. My lord, in the opinion of this court, the entire argument that the rainy waters could not have washed away the check fails into significance and is not argument worth consideration. More particularly when the respondent accused is on unclear terms that he accepted his liability of his having accepted the amount of his 22.50 lakhs from the complainant and is also declared the issuance of the 7 checks of particular debts towards such legally enforceable debt. It is in that case. My lord, kindly comes now to paragraph 11.
Paragraph 11. Yes.
Having given anxious consideration to rival submissions and having examined the record, we are clearly of the view that as regards the conviction of the appellant accused for the offence under section 138 of the Negotiable Instrument Act, the impugned judgment and order dated 8/1/2018 does not call for any interference that is there.
Yes.
My lord, kindly comes, my lord, now to paragraph 13. For determination of the point as to whether the High Court was justified in reversing the judgment and orders of the trial court and convicting the appellant for the offence under section 130 of the Negotiable Instrument Act, the basic question to be addressed are twofold. As to whether the complainant respondent number 2 has established the ingredients of 118 and 113 of the Negotiable Instrument Act so as to drawing of the presumption envisaged therein, and if so, as to whether the appellant accused has been able to displace such presumption and to establish probable defense, whereby the onus would again shift to the complainant. 15. So far as the question of existence of basic ingredients of drawing of presumption under section 118 and 113 of the Negotiable Instrument Act is concerned, apparent it is that the appellant accused could not deny his signatures on the check in question that had been drawn in favor of the complainant on the bank account maintained by the accused for a sum of rupees 3 lakhs each. The said checks were presented to the bank concerned within a period of their validity and returned unpaid for the reasons of their balance insufficient or account being closed. All the basic ingredients of section 138 as also of section 118 and 39 are apparent on the face of the record. The trial court had also consciously taken note of these facts and had drawn the requisite presumption. Therefore, it is required to be presumed that the checks in question were drawn for consideration and the holder of the check, that is the complainant, received the same in discharge of an existing debt. The onus therefore shifts on the appellant accused to establish the probable defense so as to rebut that presumption. 17, my lord. Paragraph 17. Paragraph 17, madam.
Yes, yes.
On the aspects relating to preponderance of probabilities, the accused has to bring on record such facts and such circumstances which may lead the court to conclude either that the consideration did not exist or that its non-existence was so probable that the prudent man would, under the circumstances of the case, act upon the plea that the consideration does not exist. The court has time and again emphasized that though there may not be sufficient negative evidence which could be brought on record by the accused to discharge his burden, yet mere denial would not fulfill the requirements of the rebuttal as envisaged under section 118 and 113 of the Negotiable Instrument Act. Now, my lord, paragraph number 18. In the case at hand, even after purportedly drawing the presumption under section 113 of the Negotiable Instrument Act, the trial court proceeded to question the want of evidence on part of the complainant as regards the source of funds for addressing loan to the accused and want of examination of relevant witness. This is not required here. Who alleged extended his money for advancing the accused. This approach to the trial court variance that after the presumption, the onus shifted to the accused, and unless the accused has discharged the onus by bringing on record such facts and circumstances as to show preponderance of probabilities tilting in his favor, any doubt on the complainant's case would not have been raised for want of evidence regarding the source of funds or advancing loan to the appellant accused. As aspect relevant for consideration had been as to whether the appellant accused has brought on record such facts, material circumstances, which could be a reasonably probable defense. So that now, my lord, paragraph 19.6, page 123. The fact of the matter remains that the appellant could not deny his signatures on the said writing, but attempted to suggest that his signatures were available on the blank stamp paper with Sri Jagadish Bhai. This suggestion is too remote and too uncertain to be accepted. No cogent reason is available for the appellant singing a blank paper, stamp paper. It is also indisputable that the checks, as mentioned therein, with all the relevant particulars like check numbers, name of bank and account number are of the same check which form the subject matter of the complaint case, the said account, well, this is there. Well, paragraph 20. My lord, I will come to my lord the fourth line from the right, the observations of the trial court. The observations of the trial court that there are no documentary evidence to show the source of funds with the respondent to advance loan, or that the respondent did not record the transaction in the form of receipt of even kacha notes, or that there were inconsistencies in the statement of the complainant and his witness, or that the witness of the complaint was more in the know of facts, etc., would not have been relevant if the matter was to be examined in reference to the onus on the complainant to prove his case beyond reasonable doubt. These considerations and observations do not stand in conformity with the presumptions existing in favor of the complainant by virtue of section 118 and 139 of the Negotiable Instrument Act. Needless to reiterate, the result of such presumption is that existence of a legally enforceable debt is to be presumed in favor of the complainant. When such a presumption is drawn, the factors relating to the want of documentary evidence in the form of receipts or accounts or want of evidence as regards the source of funds were not relevant of consideration while examining if the accused has been able to rebut the presumption or not. The other observations as regards any variance in the statement of complainant and witnesses or want of knowledge about dates or other particulars of the checks or washing away of the earlier checks in the range, though the office of the complainant being a court has been irrelevant factors for consideration of a probable defense of the appellant. Now, my lord, paragraph 21. Second line, we are of the considered view that the trial court appears to have proceeded on a misplaced assumption that by mere denial or mere creation of doubt, the appellant was successfully rebutted the presumption as envisaged by section 139 of the Negotiable Instrument Act. In the scheme of any Negotiable Instrument Act, mere creation of doubt is not sufficient. Paragraph 22, my lord, the first line. The result of discussion in the foregoing paragraphs is that the major consideration on which the trial court chose to proceed clearly shows its fundamental error of approach where, even after drawing the presumption, it has proceeded as if the complainant was to prove his case beyond reasonable doubt. That's all, my lord. I repeat this judgment. My humble submission in one line, my lord, is that the complainant has to place before the court and show the court the check that he has extended a loan. In this case, he admits his signature in the check in his evidence, as well as he admits that his wife has given the money, for which he gave that exact amount of 8,60,000. And he also kept his deed of his house secured that as a security for the money. The accused, his house deed was kept as a mortgage, as a security. It's still lying with the complaint, which almost shows that he has taken the loan as a security. He has kept that with the complainant. Now, my lord,
But
the complainant.
but the document says it's not he. She has kept everything.
No, he has, my lord. Well, let us come to that part once. Yes, he's the husband. He takes all responsibility. He appears as a witness also for her.
For her,
Huh.
she was not prosecuted.
He has given the check signed by the husband in lieu of his debt.
In lieu of the debt incurred by the husband.
Both took the loan, my lord. That is my submission.
Okay. So in discharge of joint liability,
Yes, absolutely. Absolutely, man.
that is your case.
That is why he issued the check.
Okay, fine.
My lord will kindly comes to, my lord. My lord will come to page 9.
Page 9 of the paper book.
Yes, paper book.
Yes.
It is a fact that as per declare, my lord, the 1, 2, 3, 4th line. It is a fact that as per declaration on the money received exhibit A, a deed of accused has been kept mortgaged.
Yes.
That is a deed of that house that we mentioned Hidaram Benajine.
Yes.
So, my lord, if the prosecution, whether he has issued receipts or not, all these are false in the prosecution case. Finding false in the prosecution case will not absolve the accused from rebutting his liability under section 130 Negotiable Instrument Act.
Thank you.
That is all is my submission.
Thank you. Would you like to? Yes.
But I did not.
3 minutes.
My lord, your lordship has seen the complaint.
Yes.
In the complaint, it has been category paragraph 4, first line. Your lordship has seen.
Yes, yes.
And my lord, he wanted to
Hmm.
internal page 2, paragraph 4. First
Yes,
line.
yes.
And my lord, in the receipts which we wanted to my lord, the prove, but all those receipts will show that either it was signed by null or by the person that accused number 2. One of the instrument, I was
No.
there as a witness.
That's fine, but let me see the order sheet. After invocation of section 200, what happened?
Yes, my lord, why was-
But in 200, there is no such
Against
indication.
the accused person. Who was the accused person?
In 200, my lord, there is no such indication to that effect.
A prima facie case has been made out by the complainant under section 138 NI Act against the accused person. Now, who are the accused persons? Both two persons were prosecuted
Yes,
initially.
after by an order of a magistrate, my lord, the accused number 2 was exempted from this case.
Yes, learned trial court had every reason to whom the notice was directed.
Both,
138B,
Both.
both. Have you gone through the notice?
my lord, I find it in the paper book.
In the paper book, just show me. Just show me notice was addressed to both.
My lord will kindly come to page 3, the complaint, paragraph number 7.
Yes.
The thereafter your petitioner served a notice upon the accused persons on 29/4/2003 through his learned advocate Ms. Shomila Nath by registered post with AD, and the accused person received those notices on 30/4/2003 and on 1/5/2003.
Hmm.
So far as the page 8 is concerned, so
Hmm.
far as the 3 documents, exhibits, A,
Hmm.
B, and C.
Hmm.
But there your lordship will find in the first money receipt, which is marked as exhibit A, the loan was taken accused Paramita Dev.
Yes.
And my lord, that also one of the examination in chief reflects so.
No, why filed? Is she dead?
My lord,
There is an endorsement against accused number 2 as filed. Why?
that
My lord, I
find one of the following
I don't
record.
remember somebody.
But I was really searching for that. But the other part, but I want to rely one judgment, but your lordship knows. Tahida Singh versus Narayan Das.
My lord, in one, I don't remember which part of the paper book I saw that by an order of the magistrate it was.
Yes, yes.
I was searching for that order only.
Notice was issued to Shomende, exhibit 6, with a copy marked to
Original
Paramita Dev.
borrower. But I am only an witness to the transaction of loan. I cannot be held liable for the debt.
You have owned the vicarious liability and issued the
Malab, that is that.
Husband and wife, my lord.
at a time.
Malab,
Why at a time?
Shotir Punne Potir Punna.
Husband and wife, had it been Ram and Sham, my lord, I would have been husband and wife. One more thing, my lord. Acha,
Show me the law.
Come.
Show me the law.
My lord.
If wife borrows money, husband incurs the liability to repay.
That time they were together, my lord. So that is quite, it is when
Huh?
can he?
Don't be dependent on morality.
No, like irrevocable conclusion. that it-
Legally you show
My lord,
that
husband
husband
and-
incurs.
This is not a part of this case, just an argument, my lord, that husband and wife generally each one comes for the other when the marriage is subsisting. And just
So if the wife commits an offense, say for 10 years imprisonment,
No, my lord.
husband should come and serve out 5 years
never.
for his ardhangini. That is what you are arguing.
Oh, here he took up the onus on himself for the wife to give the check. Check was given by him, it was admitted, my lord.
Madam, দেবো ডিকটেশন দেবো অ্যাপিলটা
My lord, ওনার হয়ে গেছে?
আমার কিছু বলার
Then
নেই।
only one thing, my lord.
only on point of law.
Only,
He doesn't say anything. What he would say?
my lord, only one line I will add, my lord.
Hearing
In-
concluded.
Yes,
This is for
in
judgment.
most of the cases, my lord, in case of 139, we do not even find receipts given by the complainant. Yeah, I have given a loan.
But
And in
here,
all those cases, my lord,
but
convictions have available.
here unfortunately or fortunately,
Yes,
acknowledgement is
but,
here
but my lord, there is,
as exhibit A, B,
my
C.
lord, that is of no consideration in a 139 because if the accused has admitted his signature on the
Thank
check.
you, sir.
Yes.
Thank you.
But
I
I
will
have
follow
already
the
relying on
procedure.
judgment, but I could bring the book, I am not necessary.
Okay. I'm grateful, my lord.
But
Deeply obliged.
ও নামটা
নাম দিয়ে দাও।
Hey, Aditya, চেম্বারে দিয়ে দেন তো এটা।
I'm grateful, my lord.
May I be permitted to mention one?
No.
Lord,
Wait.
only for adjournment, my lord. It's item 20.
Don't indulge in discipline. We are imbibed with that concept of indiscipline, at least within the courtroom. Don't do this. Wait, list will be called. Call the list. Yes.
Not I am for the appellants.
You're for the appellant.
Fine.
What's the appeal about?
Well, at conviction under section 324, sentence is of 1 year. Well, there are altogether 12 witnesses, they deposed to prove the prosecution case. Well, the appellants, they are on bail. From 2003 till date, for last 20 years, my lord, they are on bail.
So why can't we notify the victims? Let them come.
My lord, victim can be notified, subject to, my lord, there. Now the law is well settled that victim has to be notified in case there is a direction for compensation. But there is no direction for compensation. My lord, kindly comes to page 81, running page 81 and internal page 34 of the judgment.
Yes.
My lord, order portion starts from page 80, turn and leaf page 81. I do not find any direction so far the fine or compensation is concerned. Page 82 also. My lord, in such a circumstances, notifying the victim subject to correction, my lord, does not arise.
But again comes the question of fair play. Let them come join. What's the harm?
My lord, so far the question of fair play is concerned, if your lordship so desires, my lord, let them join the
Is there
appeal. I have no issue with that.
any scope of appellant being prejudiced?
My lord,
I
there
don't
is,
think so.
my lord, there is hardly a scope of being prejudiced, but the point is that, my lord, even if your lordship desires that they should join the appeal, in that case, my lord, only thing is that, my lord, they cannot argue the case. Because until and unless there is a cross appeal, now all they can do is that, my lord, they can assist the public prosecutor, the state only. And by filing a written argument, that's all.
No, you were talking about the procedure for trial.
No, even in appeal also. Even in appeal also.
Then 374. Let us revisit. Appeal 372 unless other no appeal shall. 372 provided in person central. Yes, you are correct. Proviso doesn't say blanket right, yes.
Well, he can assist. Victim can always assist the
Not required.
public.
Mr. Roy is competent enough to assist.
Yes, he is always good. He is. আমি আজ পড়ে নি কালকে তুমি তার কি করছো না একটাই পেপার পড়ে তুমি জেরক্স করে নেবে হ্যাঁ
Yes,
আমি একটা নোট নিয়ে নাও তুমি একটা নোট নিয়ে নাও page 2.
Page
2 is the letter of complaint.
yes.
The letter of complaint was directed to the officer in charge of Polba police station at HON'BLE. It is my earnest appeal to you that a quarrel took place on last 21st May 2003 between Shoilen Malik and Gaur Khara. The inmates of these two families were also involved in this dispute. But the turbulent condition soon faded away because the members of these families took venture to settle the matter in a peaceful way. After that, today on 22nd May 2003, my elder brother Gaur Khara went to Baturia in the morning. He was severely beaten by some persons while he was returning to his home. He was hindered by some women and they started to beat him severely, which was actually the outcome of the quarrel happened yesterday. Owing to this incident, I went to Polba police station to complain against them at about 10 a.m. Returning home, I saw that some of my neighbors came to assault my elder brother Gaur Khara about 12 p.m. They are Gopal Pakhira, Ajit Pakhira, Anil Malik, Sunil Malik, Mohan Adak, Shoilen Malik, Indrajit Malik, and Sagar Malik, father of Shoilen Malik and Indrajit Malik. They assaulted my elder brother Gaur Khara with scale, saw, etc. They cut the thumb of right arm of my elder brother. Apart from this, they also assaulted my old mother and broke her head with a stick and also hit on my younger brother Jagannath Khara's right hand. His hand is probably broken. They all broke into the room and tortured mercilessly. After that, we went to Polba police station and then went to Polba BPHC. Polba BPHC referred the patient to Chinchura hospital. All of them are undergoing treatment there. I shall be highly obliged if you kindly take positive steps. My lord, on the basis of this letter of complaint, the case was started under section 147, 148, 149, 341, 324, 325 of the IPC initially. Now, my lord, kindly turn to page 5, the charges. Now, the charges were framed under section 148, the first one,
In the second place, 324 by 149. In the third, 149, there is a section, my lord, there is an interpolation only section
307.
Yes. And then a 326.
Hmm.
Now, my lord, late, kindly do not take me wrong. May I be permitted to first place on record section 212 once? CRPC speaks of time, place, and person. That is there. Now, my lord, may I take your lordships to once to section 219?
219. Fine.
It starts with 219, section 219 of CRPC.
Yes.
It starts with 3 offences of same kind within a year may be charged together. Subsection 1 says, when a person is accused of more offences than one of the same kind, committed within the space of 12 months from the first to the last of such offences, whether in respect of the same person or not, he may be charged with and tried at one trial for any number of them not exceeding 3. Now, my lord, in this case, the charges were framed against 5 persons, 7 persons. Now, even there are 7 persons, my lord, they were jointly tried, my lord, for commission of an offence, which is the resultant effect of a written complaint or letter of complaint. Now, every single person, even if they are charged together, then also, my lord, they cannot be tried at one trial for any number of them not exceeding 3. Now, in my case, the charge was framed under 4 heads, more than 3. The court could have framed charge under 3, putting section 376 with section 324. But my lord, court has framed charge under 4 heads, which is absolutely defeating the provision of subsection 1 of 219. That is, my lord, it's not a technical issue altogether.
Now tell me about question of your being prejudiced as well.
Yes, my lord, I'll come to that. Only, my lord, since I am placing the paper book, my lord, I am taking your lordships to this. Since I have taken your lordship to the framing of charge and I find there are 4 charges, my lord, I take your lordship on to 219. My lord, at the time of argument, I will cover everything. My lord, prejudice
Mr. Jana,
is something, my
Mr.
lord.
Jana, are you not arguing the appeal? Then we should call it a day because I have some other works inside. I have to dictate the appeals. So if you don't want to conclude, then don't begin.
Next week, then.
Next week, very well.
Tomorrow and
Very well. Come back next week.
kindly fix a date subject to.
Yes, you suggest.
Subject to last time convenience.
I'm stationed here. Only on 4th of May, I have some difficulty. There is division bench.
My lord, on
4th of May.
4th of May, my lord.
Other than that, you suggest?
My lord, on 10th.
10th of May.
10th.
10th of May, আমরা কোনো অ্যাপিল রেখেছি দেখুন তো একটা রাখা আছে
or 11
কমন 11
on 11 at 2 p.m.
Heard Mr. Jana
No.
and Mr. Chatterjee Learned Counsel representing the appellants. The matter is adjourned to appear on 11th of May under the same heading.
Will Mr. Rai is then appearing?
Yes, Mr. You will be representing the state? Regularize?
Yes.
No, I don't have the authority. For that, you need to go to the learned public prosecutor and who am I to regularize?
No, my lord can direct the public prosecutor office to do it.
Yes.
I'm grateful.
Who used to represent the state? কে থাকতো আগে কে ছিল? Then I'm directing. I am then directing the PP you get it regularized from that office. That would be better, Otherwise,
After the appeal is over. So when the
no, that Mr. Chatterjee will lend you, don't worry.
কি কিসে হ্যাঁ সেটাই তো বলছি।
But that's the end of the story. Learned public prosecutor is requested to depute an advocate, depute a panel, a lawyer from the panel.
But then my lord, it will go to some.
So you want,
I do not know, my lord.
so you want me to nominate?
My lord. Then it will come to us.
Then you have to go through between the lines and you have to come back, The way Mr. Jana has started his argument.
My lord, Mr. Rai has a 3-story building at Purnodas. And another at Lake. My lord, I wanted a rented accommodation for my chamber in the ground floor. My lord, I supplied him the copy, but still he's not agreeing to that.
That is the difficulty. He will hardly find any time to go through paper books. He has to look after the
Exactly, so many properties
palatial
in the
buildings.
city.
Yes, he is owning.
So many properties in the city.
Miss Dash and Mr. B.K. Roy.
Mr. Brigadier and Mr.
I'm sorry, Mr. B.K. Roy and Miss Das are found present to represent the state. Very well, you come back. I am not saying anything. I don't want to regularize any of your.
No, it is sufficient.
Then to item number 10 or something. Take it in. Here. Do you drive, sir? Do you drive car or motorbike?
Yes, no.
Yes, which is why you have developed the habit of cutting the lane. Wet. Yes. Call the list. Owner কত number আছে? What is your number?
28, my lord.
28. So come tomorrow.
That is the difficulty. Otherwise, it will be listed on tomorrow.
Huh?
If I will not take adjournment, it will be listed on tomorrow.
It will be listed on tomorrow. It will appear tomorrow.
This matter is very old matter.
Yes.
I could not trace out the brief.
You don't have to spend some time, go through the record of the court and get yourself prepared. 28 tomorrow. Come back tomorrow.
My lord, item number 51.
50?
51.
51
In the
tomorrow.
morning, I had also.
Tomorrow, not today.
My lord, I spent entire day in my lord's court just to get an adjournment.
Was it a painful experience for you?
No, my lord, it was.
It was a
First
pleasure.
experience.
So, what's the point? If you have enjoyed this, enjoy it, come back tomorrow.